Yes, hello everyone. In this video, I'm going to talk about pleading breach of statutory duty. Um, in the common law world, and especially in the jurisdiction of England and Wales, and I suppose that pleadings are almost of a universal application because they depend on and they're based on the same theories that you should notify the other party of your case, and that the judge and the other party, your opponents, should be in should be in a place to know what you're claiming against them and what you're not claiming against them, and so that they can put forward their defense adequately, and etc. The court can know what other faction issue the relevant matters, so it can base its decision, its thinking, its reasoning on the pleading. So pleadings are really the pillars of the presentation of either party's case. Um, Now, a pleading. How do you plead a statutory duty, a breach of statutory duty? Now, statutory duty is a duty that is imposed by law. It's imposed by regulation. Okay, it's not a common law theory. It's not a common law offense. For example, just like negligence. You got with negligence like the elements that make up the offense. You need to show that there's a duty of care. Then you need to show that there's a breach of that duty by the person by the person to whom the duty is imposed on. You need to show causation. You need to show that you have suffered certain damages. Now, with a statutory duty, there is a duty. Yes, that's why sometimes we tend to this tends to overlap, or even we tend to confuse it for the tort of negligence, because it deals with duties as well. But with statutory duty, you don't have those fixed set of elements. You The duty is going to be breached when um, the criteria that the statute lays out uh, are not fulfilled. For example, when those criteria are breached, then the duty is breached as well. And I'm going to give you an example. Consider this. Consider that if I fail to lock up the door of my room, let's say supposedly that's a statutory duty. It states that if I fail to lock up the door of my room, I will have to pay damages to my neighbor. So let's say, I know it sounds like a very, it's a very unreal, surreal example, but I'm just giving you the core idea of what a statutory duty may be. It's just anything could be anything, just because it's been passed by the legislature and it's not based on common law. So, if I fail to lock the door of my room, I'm gonna have to pay damages to a certain class of people, to my neighbors, or to my roommates, to my housemates. Right. So if I fail to do that, I'm gonna have to pay damages. That's a statutory duty, and if I fail to do that, I breached it. Now, if I fail to lock up the door of my room, and as a result, I knew it was foreseeable by me that someone could have been damaged because failing to lock the door would because the door was defective, and failing to lock it up could foreseeably, by me and knowledgeably, traumatize or injure one of my housemates, to whom which I could or I could not actually owe a duty of care. Well, in that case, I'm gonna have to show that I owe them a duty of care. That I'm gonna have to show, like if I claim negligence, I'm gonna have to show that I failed, to lock up my door. I'm gonna have to show also that I breached that duty by being negligent. I have to show foreseeability. I'm gonna have to show causation. I'm gonna have to show damages, and you know that's what we're gonna have to show basically against me in order to claim negligence. So, failing to lock up my door could be an act that's part of maintaining the claim of negligence against me, but does not on its own provide a groundwork, provide a foundation to sue me um, for negligence. There need to be all these elements established. That's what I'm trying to say. Even it's easy to establish them, you need to establish them. However, with the statutory duty, if the statute provides so, then that's it. Somebody can just claim damages just because the statute provides so. If it provides that I failed to do a certain act, there you go again. So when you plead a statutory duty, because it's not really, like there are hundreds of statutory duties. Your opponent will not know if you do not identify the statutory duty that you are actually pleading in your pleading. The basic rule is that you cannot plead law when you plead. You just plead facts, because you gotta have to keep it simple. If you plead way too much law, for example, that's not really going to make you vulnerable to a strikeout application by your opponent of your entire pleading. But on an extreme case scenario, it might tend to complicate and make your pleading embarrassing, thus making it more prone and vulnerable to a strikeout of a pleading, which is kind of an extreme case. But your entire paragraphs may just be struck out based on the fact that they are irrelevant, or they could just be scandalous based on the fact that they really don't need to be there. However, we're not going to talk about strikeout applications in that video. I'm gonna have to say that the rule is that when you plead something, for example, negligence, you're not going to plead any sort of provision, you're not going to plead any sort of law. But when you plead statutory duty, it's inevitable. There's an inevitability of not pleading the statutory duty, because the other party needs to know what the statutory duty is, and the reason he needs to know and the judge needs to know is so the other party can potentially identify that and put forward his special defense, right? That is to be found where else? In the statutory duty. There's no some sort of a common law, preset, prefix defense. For example, like if I'm claiming negligence, he could put forward like certain defenses, like that are basically afforded by the tort of negligence. But when I claim statutory duty, the opponent will have to know the statute that I'm calling, that I'm invoking, so he can put forward his defense. So first, I have to identify the statute, and secondly, I'm gonna have to plead the facts that will bring me within the meaning of the statute. Right? There's certain facts that I have to plead that will bring me within the wording of the statute and will show that I have breached the statute. Let's say that I didn't invoke, for example, the statute. Now, how would the judge or how would my opponent know what kind of claim I had? Was it a claim in negligence? Was it a claim of what? Was it a claim of under the offense of misrepresentation? Was it a claim under the offense of battery? Why is it there? And if I just tend to clatter my pleading with a lot of facts just like that, I'm expecting my opponent to just mysteriously and surprisingly, magically know what kind of statute I am referring to. That's not going to happen. So, by identifying the statute, I let my opponent know and the judge know what I'm actually referring to, so they can prepare an answer to me. So, if, and last word, if I have set facts, if certain facts that I have, certain paragraphs that I've used under separate heads of claims and cause of action. If I mention them early in my pleading, I can mention them again, and for the sake of simplicity and not cluttering my pleadings, for the sake of non-repetition, I can incorporate certain paragraphs by reference and adopting them under the breach of the certain statutory duty, uh, so I won't have to lay them out again and cause certain inconvenience and probably eye strain and to the my opponents and the judge. So I can keep it simple. So refer, identify the statutory duty, and plead the facts that will bring me within the wording of the statute that presumably I claim that has been breached. This is Dimitri Koulafetis. This is not legal advice. This is just purely for educational purposes only. You're free to make your own research and see what you can get out of this. Thank you very much. I will see you in my next video.